first matter to come before the court this morning is State of Ohio versus Dale Ivey. Both sides would have 15 minutes to argue. The appellee has waived, so you have 15 minutes to present oral argument this morning. We have read the briefs. We're ready to go when you are.
May it please the court, Donald Gallick on behalf of defendant appellant Dale Ivey. Obviously, I'll reserve no time for rebuttal. We have 5 assignments of error before this court, and I'd like if the court would indulge me to address them out of order. I think that would be very pertinent on this kind of case because I think this case, more than any other appeal that I've handled in my career, have had more timing issues than anything else. And what I mean by that, looking at assignment of error 4 and 5, we're talking about sentencing issues where there's a question that comes up: is allocution something that has to be afforded before you impose sentence, or can you impose sentence and then give the right to allocution? I say that timing is everything in this issue, that a trial court under Criminal Rule 32A and the State versus Green and all the other Ohio Supreme Court precedent that I cite, allocution needs to come before sentencing. And that interrelates to assignment of error 4, where the trial court gives a maximum sentence for escape and then says, let me tell you why maximum sentence is a good sentence in this regard. That, again, I say that timing is everything, and the court should provide the reasons for the maximum sentence before announcing it, just as allocution should be granted to the defendant before you announce your sentence. Another timing issue, going to assignments of error 1, 2, and 3, all 3 of these assignments of error now have new Ohio Supreme Court precedent that we didn't have when the briefs were filed. I probably could have asked the court to amend the briefs, but I know that doesn't usually sit well and slows down the docket. As to assignments of error 1 and 2, this raises the old chief issue that I'm sure this court knows I've brought up more over and over and over again, only to be denied. However, now we have the State versus Creech opinion, where the Ohio Supreme Court says, yes, we should apply the U.S. Supreme Court opinion of old chief versus United States. That's important. Why? Because in the trial transcript, at some point the trial court says, I can't make the prosecutor stipulate to these prior convictions. Kind of like, I wish I could, but I can't. But now we have the Ohio Supreme Court saying, and there might be an issue that this court needs to address, is that something that is retroactively applied? I will point out that much in the Creech opinion, as well as the old chief opinion, it does touch upon due process issues. In the trial at bar, you have the prosecutor telling the jury, this guy was convicted of aggravated burglary in 1987. This guy violates parole all the time. This guy's got all kinds of felony convictions. Why is that a due process concern? Because under the U.S. versus Bell opinion that I cite all the time from the Sixth Circuit, the Sixth Circuit says, a jury says, once a criminal, always a criminal. That when the jury's allowed to be tainted and said, this guy's been getting convicted of felonies going back to the 1980s. This guy's a dangerous aggravated burglar. So then you have a question of aggravated murder, and a jury says, well, he must have done it. He's a career criminal. He's violated parole. He's been convicted of all these prior violent felonies. Under the old chief opinion, had it been applied, and now under the State versus Creech, I hope it will be applied in all prospective cases, the trial court, with the defense counsel motion, upon defense counsel motion, can say, you know what, if you want to bring it in, you're going to have to stipulate to limit that. And maybe you say, look, the defendant has a prior felony conviction. What is it? Don't worry about it. Both sides agree there was a felony conviction. The jury does not need to know what it is, does not need to see the journal entry of what it was. And certainly in this case, an opening statement should not be told to prejudice them right out the bat. This guy's got aggravated burglary convictions going back to the 1980s. The Creech opinion is controlling now on assignments of error 1 and really 2, because Rule of Evidence 404B is, it's less of a constitutional issue, more of a procedural issue. But 404B does apply to that Creech opinion. I'm sure this court has the citation for it. I could provide it if the court doesn't have it.
No, that's not a problem. I'm sorry.
Sure.
I'm sorry, I shouldn't speak for the presiding judge, but I was just wondering, you didn't file any supplemental authority. Not that you're required to, I'm just asking you didn't.
That is certainly an error on my part.
No, I'm not saying that. I'm just asking if I missed it or something.
No, I missed it.
Okay.
And to go into that, the other thing that I missed on assignment of error 3, which I think is certainly a tougher issue, but because we have an aggravated murder case, State versus Walker, and both of these cases came out at the end of December from the Ohio Supreme Court. And of course, the Walker citation is 2016 Ohio 8295, and that deals with aggravated murder, and is the state required to show purpose and prior calculation and design. Again, I think this court might have to make a decision, is that something that is retroactive or is that something that's only prospective? But obviously that's a very important case that again came out, I believe December 29th or December 30th, right at the very end of 2016. That's a much tougher issue because I know that there's a lot of evidence pointing at Mr. Ivey, but the question is, even if Mr. Ivey did cause the death, was it an accidental death, was it a purposeful death, and certainly did he have prior calculation and design? There's trial testimony suggesting they might have gotten into some sort of animated argument, or there might have been some sort of provocation, who knows? Had the Walker opinion been applied at that time, it didn't exist at that time, but if it applies to this case, you might have a different outcome, at least on the aggravated murder. We might be just here on a straight murder. I do think in my statement of the case, I erroneously say we're here on a murder conviction. We're here on a murder conviction and an aggravated murder conviction. Maybe that was wishful thinking on my part, that we should only be here on a murder conviction and the aggravated murder should be vacated. That's premature on my part. Regarding those issues, obviously it's all about timing. I think with the sentencing, allocution has to be before you impose sentence. The findings for a maximum sentence should be issued before you announce the sentence. And then we have assignments here 1, 2, and 3. We have this 2 new cases coming out of the Ohio Supreme Court in late December. If there are no questions from the panel, I think I've put forth everything that I can.
What would your argument be if we decide Creech does not apply retroactively?
Well, then I think, there's going to be a new line of litigation. And who's this, I didn't...
It's a more difficult argument for you.
Well, it is. No, it absolutely is. And I think it comes down to if the court looks at the Creech opinion and decides that it's more of a procedural question or if it's more of a constitutional concern. I think if you say, yeah, looking at how the Ohio Supreme Court wrote Creech and how they interpreted Old Chief versus United States, these are constitutional concerns. These are due process concerns. You say that's not retroactive, I think that's a problem. If you say, well, it's really they're more interpreting Rule of Evidence 404B. Do you have some great right to apply the rules of evidence retroactively? Well, we can change the rules of evidence, pretty much at will. I mean, there's a notice and comment period. But I think if it's strictly procedural on the rules of evidence, then I think there's a greater argument for limiting the retroactivity. I'm hoping the court sees it more as a constitutional due process issue, obviously. If there's no further questions, I thank the court for its time.
Seeing none, thank you.
Thank you so much.
The court will take the matter under advisement, issue a written decision, which will be mailed to all sides as well as posted on